Okay, so I'd like to welcome everyone tonight to Canadian Law Study Group study session. Today's date is February the 23rd, 2023. Tonight I'm going to talk to people about the Constitution Act of 1867 in order to use it as a method of establishing jurisdiction. There's actually 4 elements of jurisdiction that essentially need to be met when you are going to court, whether you are the claimant or whether you are the defendant. There are 4 essential elements, and more often than not, people don't realize the importance and magnitude of the Constitution Act of 1867. But before I start jumping into the Constitution Act to show you how I make how I am doing my research, so other people can see how I'm doing my research, so they can start applying these principles to their research if these principles make sense to them. I do want to make an acknowledgement tonight with respect to whether or not the Constitution Act of 1867 and or the Constitution Act of 1982 is even valid. Unfortunately, and I say unfortunately, I've been in several debates with some people who never presented their argument to me. They may have made one comment here and one comment there, but they didn't present all of their argument to me. And in doing so, they failed to establish the essential elements of their argument to give me something to work with. Now, it came to sort of a head today, and indirectly through third parties, I finally got this person's argument, and there is some merit to it. I am going to be looking into it. And when I say there's some merit to it, it does look like there is potentially grounds to say that the Constitution Act of 1982 is not valid, and quite possibly the Constitution Act of 1867 is not essentially valid, as it does lack royal assent. But I only just got the full argument presented to me indirectly this evening. Now, having said that, upon its face, what I do want to point out to people is that the Constitution Act of 1867 does still confer the authority that all the legislation and all these legislatures and the judiciary are operating under. And as far as they're concerned, it is, from their perspective, valid. I'd also like to point out that from their perspective as the public servants, they're subject to these rules. And we're not, because what I pointed out in one of my write-ups in my blog maybe about a week ago, they're always pursuing us for breaking a rule, but they're subject to the rules. So they are subject to, and if we allegedly break a rule, then they're in pursuit of us to hold us to account to the rule. So there's a difference there, because again, they're the servants, we're not. So until we are able to resolve our constitutional issues in Canada, so long as they still consider the Constitution Act the supreme law of Canada, I don't see why, if you don't go into court with something, you have nothing. And so you have to come into court with something. So long as you can present your arguments in a logical, sensible way, using the rules and showing how they are not following their own rules, that will be the start of fixing our constitutional issues in Canada. So I'm going to start by talking about the Constitution Act of 1867 with respect to 2 things. I'm going to start with the Reopening of Ontario Act, because I would like to demonstrate to everyone the issues with the Reopening of Ontario Act, because I've found quite a few issues with it in the last week, which I have brought to the attention of His Majesty the King, the Minister of Justice, and Attorney General of Canada, the Attorney General of Ontario and Writ of Ontario, Canada, as well as all the Crown attorneys, prosecutors, and municipal prosecutors, and the courts, and the city clerk, and several other parties in Simcoe County, which is where that is my home residence. That's where I reside. So I brought it to all of their attention, the issues that I've found with the Reopening of Ontario Act, to make them all very much aware that they have no authority, and how it has literally violated so many people's rights. And then I want to address in particular, the Ministry, the Attorney General, and the Attorney General of Ontario and Right of Ontario, Canada, because he broke a rule by all appearances. I say by all appearances because if he can present that he did it, then it's not him that broke the rule, it would be the Minister of Justice. But burden is now on the Attorney General of Ontario. So I'm going to go to, first, let me just check to make sure I've got the right screen up before I take you into a document. And, okay. Just about there, folks. So I appreciate your patience. And back to share screen. All right, so if I've done this correctly, we're all looking at the Constitution Act of 1867, formerly known as the British North American Act. And I'm not sure, but I think someone just tried to come into the group, but I could be wrong. This is where I really wish I had a co-host. All right, so Constitution Act of 1867 essentially sets out 3 levels of government of Canada. The 3 levels of government, I'm going to pop up the table of contents here, establishes the executive government, which is under Part 3. The executive government would be the Governor General, who acts on behalf in the name of His Majesty the King at this point. It would also be His Majesty the King, the Crown, or the monarch. And you also have, I believe it's the Attorney Generals and a few other on the legislative side. So, but the executive government is not exclusive to the legislative side. It is actually where the 2 sides come together to debate each other, I guess is a good way of saying it. I'm really not sure. But you have the executive government established under Part 3, and then under Part 4 and Part 5, you have the legislative governments created. Legislative, because you have the Parliament of Canada, which is the legislative government for all of Canada, and then you have the Constitution, the provincial constitutions, which establish the legislative authority for the regional provinces. So these regions then can make laws of Canada, but by all appearances, and I'm not going to get into this argument or this tonight in any detail, but because their power is conferred by an act of Parliament through a federal statute called the Constitution Act, their authority by that act of Parliament is, and by the provisions of the Constitution Act, is federal. It's right there. Then under Part 6, you have the distribution of legislative powers. This is where these regions split up who gets to make what laws pursuant to what subjects. So they provide the class of subject. And I'm going to go specifically to Section 92 to determine the class of subject, but not quite yet. I just wanted to show you where we're going to go. I'm going to come back. So legislatures would be the second branch of government. And then the third branch would be the judicature, which would be the judges and the courts. Now, anyone who's watched my video, Does Canada Have a Constitution? They've seen me talk about the judicature, because in particular, under Section 96, it says right there that the Governor General shall appoint the judges of the Superior Court District, blah, 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 of each province. What is very interesting is in Ontario, once the Governor General appoints the judges, then under Section 151.1, those judges enter into an agreement with the Minister of Justice, who acts by virtue of his office as the king. Okay, that comes from the Departments of Justice Act under Section 2, subsection 2. Now, what this does is you have the executive government here, and then on this side, you have the head of the legislature, and the Minister of Justice, by nature of his authority over the judges, by the agreement he gets into with the judges, the Minister of Justice becomes the head of the judicature. And so these 2 branches face off on each other with the executive government, the crown, or His Majesty the King being over both of them. That would sort of be the hierarchy as I've been able to understand it and establish it. So those are the three branches of government. And going back to the legislative branches of government brings us to the creation of a legislative enactment. In particular, tonight, I'm speaking to the Reopening of Ontario Act. Now, the executive powers of the Parliament are gained under Section 91, and then from Section 92 through to Jiminy Cricket, sorry. Section 92 through to Section 95 is the this would be the classes of subjects that the provinces, the regional legislatures, can make rules for. Now, this is where I'm going to pop into Section 92. Under Section 92, you can see all these classes of subjects. What this means is these subjects that are provided in this Constitution are provided, and there we go, are provided to the legislatures as the topics with which these legislative governments can make rules for. And if the subject
she got here, she was so skinny and others were jealous.
Hello? Okay, I'm not sure who that was. So going back, if the subject is not provided in this category, a government can't create law for it. So while I'm going to point out down at the bottom, the legislative assemblies of the provinces have the rights to create laws for civil matters, they don't have the right to create laws for human rights or natural or against the natural, anything that trespasses on the natural rights of a person. So they're restricted to civil matters only. They cannot trespass on natural rights and fundamental freedoms. So that brings us back to the Reopening of Ontario Act. And the Reopening of Ontario Act, I'm going to bring you to this website here, and it's called the Public Statutes of Ministers Responsible. And I'm just going to blank this out and see if I can bring up and I'm just going to refresh the screen here because I'd like to take it from scratch. So when you go, okay, so here it is. When you see these acts, it'll have what's the name of the act on the left on this table, Public Statutes and Ministers Responsible, and it tells you whether it's on e-laws or not. It'll tell you the ministers that's responsible and ministerial responsibilities, the date of it or when it was in the Gazette. It'll give you essentially a synopsis history of the legislation. And the Attorney General, he is not a minister, but he is an officer of Canada. You can find that under Section 130 of the Constitution Act of 1867. So anything that is assigned to the Attorney General is technically valid. Down here, you've got Minister for Seniors and Accessibility. Down here, you have Minister of Tourism. So you get the gist. You can see who the minister is. Now, I want people to be aware that titles are important. When a character is given, is identified with a styling, that styling means something. It would be like me giving you chicken for dinner and telling you it's steak. If I call it by something other than by a different name, if it goes by this name, you can't call it something else. If it is this, you can't call it something else. So a minister is a minister, and nothing but a minister is a minister. You can't call a minister something else. So bringing you to the Reopening of Ontario Act, it comes up, and the statute, Reopening of Ontario Act, it's right there. The minister responsible is the president of the Treasury Board, and the president is not a minister. Now, I went through the trouble of going through every ministry, and I'm going to see if I can just call one ministry up here quickly. No, that's an act. If not, I will. Oh, this is one of my favorite ones these days. I spend a lot of time on this particular ministry's website, but so I'll call it up again. Ministry of the Attorney General of Ontario. So here's the Ministry of the Attorney General's website. When you scroll down these website ministries, it'll get down to the legislation. So here it tells you legislation, all the acts of legislation that the Attorney General is named in some way. So he may have he may completely preside over it, or he may only be attached to it because there's some kind of court process attached to the act itself. For the Ministry of the Attorney General to exist, it has to be created. So going back to the Constitution Act, it's under section 6. I have so many windows open because I do so much research every day. So going back to the Constitution Act, under executive power, and specifically under section 63, the executive officers for Ontario is where the Attorney General's continued and recognized and continued under this Constitution. And then in section 130, he's acknowledged to be an officer of Canada. So he is a federal officer, literally acknowledged. So because he's there, going back to the Ministry of the Attorney General's website, and again, this is, I hope you guys don't mind, but I want you to see the process here. I know he has to have a ministry because he exists. So then you have to find the act that creates the ministry, because without the act that creates the ministry, he can't exist. Now, where is it? Unless they've removed it. I know it's here. Family law, property statutes, crown duties. It's down here under crown duties, Ministry of the Attorney General Act. So it's this act here, Ministry of the Attorney General Act, found on the Ministry of the Attorney General's website, that creates the ministry. It creates the ministry continued. See the ministry. So it's recognized and continued there. And then the Attorney General is also recognized and continued under ministry continued. Okay. So it's this act and this clause that creates the ministry. If this didn't exist, it wouldn't exist. So going back, Reopening of Ontario Act, President of the Treasury Board, I literally went through every one of these, and they're in alphabetical order, and I couldn't, and because there's court relations to this act, I couldn't find on this website, Reopening of Ontario Act, anywhere. I wouldn't necessarily if it was something that didn't have court related issues to it, but this one does. Reopening of Ontario Act is nowhere on this website. I went through every ministry website, and nowhere could I find any ministry website that had any link to the Reopening of Ontario Act. So it does not appear to be connected to any ministry, and the president is not a minister, so it's not connected to any minister. Also, going back to the Constitution Act, if you will. I had too many windows open. How do you like me so far? Going back to the Constitution Act and going back to executive powers. There's not a subject. Okay, we have direct taxation, we have borrowing money, we have appointment and payment of provincial officers. These are all subjects they're allowed to make rules for. They have timber and wood. You can, again, just going down the list, they have all these subjects they can make rules for. I can't find a subject that they can make a rule for with respect to locking people into their homes because they might get sick. So if you can't find the subject, well, then they don't have what you call subject matter jurisdiction. If the subject doesn't exist, they can't create the rules. And if they created rules for a subject that doesn't exist, they don't have subject matter jurisdiction. And I'm going to just throw out there, You can learn this from a course created by a Floridian lawyer named Dr. Graves. He actually has his doctorate in law, and he will teach you about jurisdiction. Now, admittedly, his is based on Florida law, but this type of jurisprudence, the rules change from place to place, but the jurisprudence remains the same. How it works, because it's all founded on English common law, it does actually, in many instances, parallel each other. So you can learn this stuff from his course. So there's your subjects. To give you an example of lack of subject matter jurisdiction, there apparently is a new ministry in town called the Ministry of Red Tape Reduction. And the Ministry of Red Tape Reduction doesn't have a subject available for it. And I'm going to flip screens here, and I'm going to call that ministry up because I want you to see this. I'm not going to be talking about this thoroughly tonight. I just want to red tape reduction, red tape. I want you to see it so you can just understand this as an example. So the Ministry of Red Tape Reduction is something that the Ontario government created, I think, since the last election. And it has a website. It has a Ministry Red Tape Reduction. We have a minister, and you scroll down, and what you don't apparently have is any legislation, which means there's no act of legislation to create this government, this ministry. There's no act of legislation to create this minister, and there's no subject matter provided for in the Constitution that even permits the existence of this ministry. So that is just being used as an example. Going back, however, just to recap really quickly, and this bar of mine is in my way. I'm going to bring you back here because we have the Reopening of Ontario Act, President of the Treasury Board. I flipped through every ministry, looking at every act of legislation associated to that ministry, and I couldn't find the Reopening of Ontario Act. Just so you know, I did the same thing with the Emergency Management and Civil Protection Act. Okay, and it happens to be the President of the Treasury Board as well. I did find this one connected to one ministry and not one ministry only, and it's not the ministry that the Treasury Board is allegedly connected to. I found the Emergency Management and Civil Protection Act connected to the Ministry of the Solicitor General. So this one has at least a connection to a ministry, but it still doesn't have a minister, because apparently the minister responsible is the President of the Treasury Board, and the minister responsible of the Ministry of the Solicitor General is the Solicitor General of Ontario. So now we have another issue. So we don't have subject matter jurisdiction provided for in the Constitution. We're not attached to a ministry for the Reopening of Ontario Act. And through just sheer determination on looking at every ministry website, I can tell you I found the Emergency Management and Civil Protection Act on the Ministry of the Solicitor General, but both the EMCPA and the ROA are connected to the President of the Treasury Board, which is not supposed to happen. It's supposed to be a minister. So what happened? So I went digging further, because now we know that we lack subject matter jurisdiction, and we also, by all appearances, lack personal jurisdiction, because if they don't have the subject matter to create the law, then they can't get personal jurisdiction on people either. So I went back to the Ministry of the Attorney General Act, and this is the second thing I wanted to talk to you about tonight, and that brings me to the Ministry of the Attorney General Act. So it turns out on the Ministry of the Attorney General Act, okay, the functions of the Attorney General is set out and established under Section 5. And it establishes that the Minister of the Attorney General is the law officer of the Executive Council. Well, that means something. And by all appearances, every Attorney General and the Minister of Justice They all have that in common. They're all law officers. And I haven't investigated every AG of every province, but I can say that both Doug Downey, the Attorney General of Ontario, David Lametti, His Majesty the King, Minister of Justice and Attorney General of Canada, and Tyler Shandro are all licensees of their law societies of their respective provinces. So they're law officers of whatever executive council they belong to. They are licensees, and they are officers of the court. So based on that skill, knowledge, and experience, it is presumed they understand how to research and construe and apply the law. And you would think the Attorney General would read Section 5 to see what his functions and roles are as Attorney General. So I find it quite interesting when I start to read this list and I get to Section 5E, where it says the Attorney General shall advise the government, and it's with the capital G, which means the executive government of the Parliament of Canada. And you see the capital G in that manner. So he shall advise the government upon all matters of law connected with the legislative enactments. Well, the way that is written should be construed and applied as if any law is to be enacted, it is to be, the government of Canada is to be advised of that, which means he's got to send it to them. So did he do that? Well, I did some more digging, and that brings us to the Statutory Instruments Act. And I found it very interesting under the Statutory Instruments Act right there, that under interpretation, regulation, right there means a statutory instrument that is made in the exercise of a legislative power. A legislative power would be, in this instance, the Legislative Assembly of Ontario. So in the exercise of legislative power conferred by an act of Parliament. Well, the Constitution Act, which is considered by the government to be the supreme law of Canada, confers the powers to the Legislative Assembly of Ontario in right of Ontario, Canada, and gives that power to the legislature to create law. But then under Section 5E, and I'm just going to flip back here, if I can get to the right one. Section 5E, the Attorney General shall advise the government of all matters of law connected with legislative enactments. So we're going to enact the Reopening of Ontario Act, and under the Statutory Instruments Act, when the government, Ontario, exercises that legislative power that has been conferred to them by the Constitution Act, then the regulating authority that's been authorized to make these regulations in reference to any particular regulation or proposed regulation, of course, being a statutory instrument, means the authority that is made for the purposes of this regulation. Now, that's very interesting, because now we know that the Attorney General of Ontario in right of Ontario, Canada, and I keep saying in right of Ontario, Canada, because I really want to hammer home that Ontario is of Canada, because its power is conferred to it by a federal statute. Well, any legislative enactment Ontario makes, or any other province for that matter, the government has to be advised of it. Now, what happens when the government is advised of it? Well, we're going to stay in the Statutory Instruments Act for a second, because down here it says examination. I'm just skipping ahead. You can, I suggest you read 3.1. Actually, I will read 3.1. So subject 2, any regulations made pursuant to paragraph 20A, which I'm not going to jump to because 20A brings you back to 2A 5.1 blah blah blah. It takes you right back to where I'm going to bring you anyway. Where regulation making authority proposes to make a regulation. So if the Ontario Legislative Assembly is proposing to make a regulation, it shall cause to be forwarded to the clerk of the Privy Council 3 copies of the proposed regulation in both languages. So based on Section 5E of the Ministry of the Attorney General Act of Ontario and the definition of regulation and Section 3.1, the clerk of the Privy Council is supposed to receive 3 copies of this legislative enactment in both languages on receipt. So once they get it, the clerk of the Privy Council, and don't forget, this is the government of Canada. This is the government the Attorney General of Ontario and Right of Ontario is supposed to advise. On receipt by the clerk of the Privy Council of the copies of the proposed regulation pursuant to subsection 1, the clerk of the Privy Council, in consultation with the deputy minister, shall examine the proposed regulation to ensure that it does not trespass unduly on existing rights and freedoms and is not in any case inconsistent with the purposes and provisions of this piece of crap and the Canadian Bill of Rights. So while it might get away with unduly trespassing on that first piece of crap, it also has to be measured against the Canadian Bill of Rights. And if it fails on any one of these 2 acts, the regulation must fail. Now, it doesn't stop there, though, because this is where it gets really fun. And I'm always so grateful for Mr. Diefenbaker and his foresight. Let me just get the right up here, because now I bring you to the Canadian Bill of Rights, which is probably my favorite piece of legislation in Canada. And under Section 3.1, so going back to the Statutory Instruments Act, it says that the clerk of the Privy Council, in conjunction with the Deputy Minister of Justice, are supposed to examine it. But Mr. Diefenbaker left us a gift, and it says right here, subject to Section 2, the Minister of Justice shall, in accordance, Section 2 down here, by the way, shall, in accordance with such regulations as may be prescribed by the Governor General and Council, examine every regulation transmitted to the clerk of the Privy Council for registration pursuant to the Statutory Instruments Act, and every bill introduced in or presented into the House of Commons by a minister of the Crown, okay, in order to ascertain whether any of the provisions thereof are inconsistent with the purposes and provisions of this part, and shall be report any inconsistency of the House of Commons at the first convenient opportunity. And then a regulation need not be examined in accordance with the subsection 1 if prior to being made it was examined as a proposed regulation in accordance with Section 3 of the Statutory Instruments Act. So if someone has already done this examination properly and in accordance to the Statutory Instruments Act, the minister doesn't have to examine it, but it has to be examined, and it cannot unduly trespass on anyone's individual rights and freedoms. And it mentions here as well up here with respect to the construction of law in Canada, every law of Canada shall, unless it expressly be declared by an act of Parliament of Canada that it shall operate notwithstanding the Canadian Bill of Rights, be so construed and applied as not to abrogate, abridge, or infringe, or to authorize the abrogation, abridgment, or infringement of any of the rights or freedoms herein recognized and declared, and in particular, no law of Canada shall be construed or applied so as to authorize blah, 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 blah. So there it is. The law cannot infringe. It cannot abridge, and it cannot abrogate. It cannot operate notwithstanding the Canadian Bill of Rights. But the Reopening of Ontario Act, nowhere is it written as part of the act that declared by the Parliament that it can do it. So if it hasn't been declared by the Parliament that the Reopening Ontario Act can infringe, abridge, and abrogate, then guess what? It can't. And so it's not been expressed. Therefore, the notwithstanding clause doesn't exist. Therefore, the Reopening Ontario Act cannot deprive the right of the individual to life, liberty, security of the person, enjoyment of property, and the right not to be deprived thereof. It's set by due process of law. And I can keep going, but literally A, B, C, D, E, F, all of those apply. They have to meet those standards without infringing, abridging, or abrogating. Okay. Now going back down, and I know this seems complicated, but this is just perseverance, right? I want to recap. The Minister of Justice shall, in accordance with such regulations as prescribed by the Governor General and Council, examine every regulation transmitted. So we didn't read that in the Statutory Instruments Act. So where is it found? Well, the Department of Justice Act, it establishes the department and the Attorney General, right? When you understand that, you understand that this is the act that creates the Department of Justice. It creates the Minister of Justice. It creates the Attorney General of Canada. And as I understand this, the minister is ex officio, His Majesty's Attorney General of Canada. That ex officio means by virtue of his office. So the minister, by virtue of his office, is the king, which is why when I send stuff to the Minister of Justice and Attorney General of Canada, it's always preceded by His Majesty the King, because according to this, he is the king and the Minister of Justice and the Attorney General. He is all three characters. Then further down, remember I told you it's supposed to be examined by the Minister of Justice, powers, duties, and functions of the minister. And it says, I'm going to skip down, examination of bills, regulations 4.1. Subject to subsection 2, the minister shall, in accordance with such regulations as may be prescribed by the Governor and Council, examine every regulation transmitted to the clerk of the Privy Council for registration, pursuant, and blah, blah, blah. My point, the Minister of Justice, under his own act that creates him, is, and subject to the Canadian Bill of Rights, has to examine every regulation transmitted to him by the clerk, transmitted to the clerk of the Privy Council. Sorry, I stand corrected. So, and I'm just going to throw this out there, Bill C-11, which doesn't talk about the Canadian Bill of being measured against the Canadian Bill of Rights at all. So we know that His Majesty the King, the Minister of Justice, and Attorney General of Canada, under Bill C-11, where's that? Right here, which doesn't talk at all about the Bill of Rights considerations. He has violated section 4.1 of the Department of Justice Act right there, because he's supposed to measure it against the Canadian Bill of Rights, because he's got to measure it pursuant to the Statutory Instruments Act. And the Statutory Instruments Act says he has to measure it against the Canadian Bill of Rights. It's all there. It just has to be found and put together. So going back, because I'm throwing in all this other stuff. So either the Attorney General of Ontario and Red of Ontario, Canada, failed to transmit the Reopening Ontario Act to the clerk of the Privy Council for examination by the clerk, the Deputy Minister of Justice, and the Minister of Justice, or the Attorney General did his job and the Minister of Justice didn't do his job. But it'll be up to the Attorney General at this point to prove whether or not he did his job with respect to the Reopening Ontario Act. So now it needs to be brought to the attention of the Attorney General, in my opinion. Yeah, I hate that word. It's not an opinion. I did it. I brought this to the attention of the Attorney General. I think I posted it on my website. I did it by email. I brought it to his attention. You, by all appearances, you broke this rule and failed to send it to His Majesty the King, Minister of Justice, and Attorney General of Canada. I'm a stickler about the names. And by all appearances, with the president of the Treasury Board presiding over this act is not connected to a ministry, it is not connected to a minister, and it doesn't even have subject matter provided for it in the Constitution Act of 1867. And in absence of all that, this law is inconsistent with the provisions of the Constitution and is, to the extent of its inconsistency, of no force and effect, subject to, because they are subject to the rules, not us, subject to Section 52, subsection 1, Constitution Act 1982, causing it to be constitutionally repugnant, contrary to, and am I in the right act? No, I'm not. Yes, I am. Contrary to Section 135, Constitution Act 1867, where it literally says until the legislature of Ontario or Quebec otherwise provides all rights, powers, duties, functions, and responsibilities or authorities at the passing of this act vested or imposed by the Attorney General, Solicitor General, blah, 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 of Canada, the Minister of Finance, blah, 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 because that's kind of by any law, statute, or ordinance of Upper Canada. Upper Canada, folks, is Ontario. Lower Canada, that's Quebec or Canada, and not repugnant to this act. So, as I said, it causes it to be constitutionally repugnant, contrary to Section 135. So, no enacted legislation in Ontario, created by Ontario, in right of Ontario, Canada, can be constitutionally repugnant. So it's a whole lot of information dumped in a very short time, but I wanted you to see the process and I wanted you to see the reasoning behind it. I'm going to do more of these, and each time I'm going to have a specific target or targets in order to show you the line of argumentation, the rules that support each argument, in order to link it all together, show the chain of custody, and show the break in that chain of custody. So other people can start to understand how the logic and reasoning may be applied if this makes sense to them. I encourage everyone to do their own due diligence. I am not giving legal advice. I'm sharing what I am doing here when I do my research, and then I collaborate with others to get their opinions. No, I hate that word, to get their feedback. And I'm not infallible. There are times when I don't know of a rule or rules that how something is being construed and applied may not be construed and applied correctly. This is why I do enjoy public debates and I do enjoy people trying to challenge me. But the thing is, people need to remember that if they're going to bring an objection to my argument to my attention, I need these people to lay out their argument and found it in law. And they need to connect, just like I've done all these connections, they need to connect the argument so I have something to work with. If you just say that's not true, and you may give me 1 point and 1 point only, you can't prove a tort if you only make 1 point. You have to link all the elements together in order to prove your argument. So yeah, I'm acknowledged tonight that there's chance that there may be in fact an issue with respect to royal assent of the entire Constitution, and that technically, do we even call it the Constitution Act or the British North American Act? I really don't know. But in either case, the point I'm going to be working on going forward is, until such time we have something to replace it with, the people who are using these acts of legislation are still, they're using them based on the authority they acknowledge as the authority that confers the power to them, that authority being Canada's Constitution. And it is possible, at least to by all appearances, to bring them back into following their own rules. As long as you structure your arguments so soundly that you give them no recourse. They either have to concede, or they're gonna have to pull out the guns, and at least then we know. And I don't mean to be so dramatic, but I think that's the point I'm getting at. We need to know one way or the other. And I don't think the conspiracies go all the way down to the bottom. I think what you have is a bunch of people who are indoctrinated, who they've been taught to do things in a certain way. They've never stepped outside of their box of thinking. And once you start to present these arguments, it may take them some time just to digest and realize, oh my God, I have in fact been breaking the law. Now, the thing I'd also like to point out is that when something like when you take a look at what's going on, everyone's got their attention focused on the top. They got their attention focused on all these characters, national, international, at the top. And like, we need to take these people down at the top. But here's the thing. You don't climb Mount Everest and start at the top. You got to start at the bottom. And you've got to get the bottom climbed first before you on your way up to the top. And if you stop and take a look at the start of this pandemic, that's exactly what they did. They didn't go after the top. They didn't go after the big businesses and stuff like that. They went after the little guy, and they didn't go after everybody. They only went after a handful of them. They charged them and convicted them and fined them money that they can't afford because they've been forced to close down and whatnot. And of course, people were denied access to their loved ones in healthcare facilities, and people were denied access to schools unless they went to forced medical procedures. And you get the gist. The harm that's been caused has been insurmountable. So my thought process on this is, we start with the courts. We start with bar grievances. We start with judicial complaints. We start with the legislative government. We bring to their attention what laws they're violating, and we make it clear they represent us. And we make it clear if they fail to act, then they can be held accountable in their personal liability. Now, I'm not telling anyone to do this. This is what I'm doing. I'm sharing what I'm doing on my website, pretty much with almost everything. There's one or two things I've held back for the short term, but I'll probably end up posting down the road. But I'm sharing so people can see what I'm doing, so they can do their own due diligence. They can do their own research. And if they decide that that it resonates with them, by all means, take my ideas as inspiration and apply them how you see fit. I'm not telling anyone what to do. I'm just saying you're welcome to use my work, but it's not to be construed or applied as legal advice. Now, I'm just going to go through the chats here, and I will also open up to any questions if anyone has any questions. Everyone's so quiet. So nobody has any questions? Okay, yes, Tara, go ahead.
Hi, it's not really a question per se. I just popped in because I was looking after my mom, but I'm going forward with we have a JR here in Nova Scotia, and I noticed in researching that the Attorney General, their job is to make sure that sorry?
Superintend? I
didn't hear that, sorry.
I'm sorry, I jumped the gun. He's supposed to superintend, right?
Mm-hmm. Yeah. Oh, superintendent. Okay. Yeah. Yeah. He's supposed to ensure that the government's following the laws that are set out for them. And so, is that the superintendent, is that a legal, duty? Yeah, okay. So, yeah, I just noticed that, as an argument going forward with our judicial review, that we should be pointing out that the AG failed their duties and whatever sections, they were constitutionally repugnant in doing, because
Well-
all AGs follow the same, in each province would follow the same, what's the word I'm looking for? Follow the same,
Principles.
yeah, that was set out by the Constitution.
Yeah, so I mean, we all start in theory with the Constitution itself. Excuse me, did the Constitution provide a subject for them to make the rules on? That's kind of a key element, because if the subject doesn't exist, they don't have the authority to make the rules. And red tape reduction is a really good example. Under what is the actual, like, subject? Hello, what subject could they possibly create this fictitious ministry? Oh, they don't even have an act of legislation to create this fictitious ministry. They just made a website. That was it. They just made a website. It means nothing. But what I would do is, once you, and I've recorded this and I'm going to put it on my website, Tara, but now that you start with the Constitution Act, if I were you, I would then go to look for your Ministry of the Attorney General Act, and I would look at the functions to ensure that the functions are same or similar to what you see in the Ontario Act, and then I would follow it from there, see if there's the duty that he has to advise the government, and then you jump back into the federal legislation, which would be the Statutory Instruments Act, the Department of Justice Act, and the Bill of Rights. And in doing that, you basically, you prove either the minister failed, either the Attorney General failed or the minister failed. So which one was it? But you have to point the finger in the chain of custody, and it starts with the Attorney General sending it up. And so you say to the Attorney General, it says you're supposed to send it up, and by all appearances, this act breaches, it infringes and abridges and abrogates my human rights and my recognized and protected human rights and fundamental freedoms, which are federal, and the law is supposed to be examined federally, which makes the law federal. So either you didn't transmit it, which means you violated this rule in the Ministry of the Attorney General Act, or you did. And if you did, show me the evidence. And if you didn't, then you just broke your own law. And wouldn't it be worth, and I'm just spitballing here, if he's a licensee, officer of the court, and law officer of the Executive Council, well, wouldn't a bar grievance apply? Just
well, yeah, our Minister of Justice, and also by virtue of that, he's also the Attorney General.
do they actually call him a Minister of Justice?
In Nova Scotia, yes.
Take a look at the act. See if the character of Minister of Justice was actually created. And having said that, I'd like to show you something. And this is so you understand.
Sorry, say that again. Character of Minister of Justice.
Yeah. So I'm going to give you an example. I'm bringing you back to my. See all the freaking tabs I've got open. I'm
Looks like my computer.
Okay. So I'm going to take you to Ministry of Finance. Okay. And I'm saying the Ministry of Finance, Finance Ontario. Ministry of Finance Ontario is the example I'm going to show you. Nope, that doesn't bring me to the website. Sorry. Let's scroll down. There we go. So there's the Ministry of Finance. So scroll down to the legislation. And because I want to find the legislation that creates the Ministry of Finance, but guess what? I find the Ministry of Revenue. I don't find the Ministry of Finance. I click on that. I scroll down. I go to section 2. And it says the Ministry of Public Service, known as in English as the Ministry of Revenue, and in French, the whatever. I don't speak French. I do apologize. And the minister shall have charge over the ministry. So they call the website. So the act calls it the Ministry of Revenue Act, but the website calls it the Ministry of Finance. And if you go into Ministers of Ontario, right? They call him a Minister of Finance, but the act of legislation calls him a Minister of Revenue. So if you're ever going to sue this official character, you better call him the Minister of Revenue, because the Minister of Finance in law does not exist.
That's right. Well,
So-
ours is a little different because, well, I'm looking at from the standpoint of when you had all these, the fines and the offenses, penalties were all
Scotia,
issued
right?
through. Yeah, they were all issued through the reopening of an Ontario Act. Ours was done through the Health Protection Act. But there is no link within the Health Protection Act. Not that I've been able to see. There has been no link between the Health Protection Act and the Minister of Justice, or the Emergencies Management Act in Nova Scotia, which issued the state of emergency. The Health Protection Act within it has the ability for the chief medical officer to issue a public health emergency, but they never did that. They didn't even do it for H1N1 in 2009. They didn't use the tools that they had within the act. And in fact, what we found was that when they issued the orders, they issued them to all Nova Scotians, when the HPA implies the application to be, the orders to be issued to individuals. So that's one thing that we found, that's obviously ultra vires, the way they issued the orders. And that's what we're looking at in our judicial review, but among other things. But I'm trying to figure out a way to get this on the table in front of the judge, because a judicial review is administrative court and they can only rule on what's in front of them. And so, yeah. So
a couple of things to keep in mind, and you can, I don't know if you can see my screen here. I'm trying to find the Attorney General of Nova Scotia Act.
There isn't one. There's just that, yeah.
I have this.
This is a PDF. This is just a description, published description of the Attorney General's role. It's not the act. There's a Public Service Act, and I haven't gone through that completely yet either. But yeah, there is no, well, from what I could see, there is no.
Let's go to the Public Service Act. So, but here's the thing. So if you can't find it, you should be contacting the Attorney General's office and saying, where is it? And in absence of it existing, then they don't have the authority, because the act creates the authority. And if it doesn't exist, they don't have it. So Public Service Act. All right, I'm not going to take much time to go through this tonight.
Yeah,
I'm gonna, but you need to go through whatever leads you find to see if either the Minister of Justice of Nova Scotia exists or the Attorney General, because here's the thing, constitutionally, there is no Minister of Justice in the province. It's only an Attorney General.
Oh,
So
see here,
because again, they love giving themselves titles that don't exist in law. Oh, we'll call this guy the Minister of Finance, even though in law he's the Minister of Revenue. Oh, we're going to call this guy the Ministry of Red Tape Reduction, even though there's no law to create him, period. We're going to call those people who are in city council at the top. We're going to call them mayors, but in law, they're head of councils. So we're going to call him a prime minister, but he doesn't exist either. He doesn't exist in law. So they give us all these names, but they're nicknames. They don't exist in law.
They're figurehead or
They're ceremonial or false, fraudulent representations, misrepresentations of who their character is. Right?
I like that term, character. I like it.
But that's a lawful term. So in law creates the character. In an absence of the character being created in law, the creature does not exist. Creature being created by, right? In absence of the creature existing, that character has no standing in law. In other words, they don't exist, and you can't sue what doesn't exist.
So our Attorney General is the Minister of Finance, or sorry, Minister of Justice, and they're also it's a one and the same, the title, Minister of Justice and Attorney General. And right now, our Minister of Justice is a DJ.
What I'd like to know,
he's not a lawyer.
Yeah, but he should be. He should be.
No,
and
he's not.
You sure?
He's a DJ. He's a DJ. I know. He was originally a counselor for the city of Halifax.
But the Minister of Justice, did they call him the Minister of Justice and the Solicitor General, or the Minister of Justice and Attorney General?
Minister of Justice and Attorney General.
Because he's supposed, again, you're going to have to read your acts, but it sounds like your acts are constitutionally repugnant because they're supposed to be,
it sounds like it.
Well, supposed to be officers of officers of Canada.
Yeah, and in the Constitution, Nova Scotia is one of the first provinces, and it's named in it like New Brunswick is. But in some of the statements, and I don't know, like I wanted to make sure I'm looking at the Constitution you're looking at. But every time I look it up, I want the 1867, but it always comes up 1867 to 1982.
Yeah, that's right. That's
the one.
Yeah.
Okay.
Yeah. So
so in it, there's different provisions for Nova Scotia for some reason. And maybe because they're one of the first. And initially, you guys were Ontario was Upper Canada or just the Canadas, Quebec and Ontario, and then Nova Scotia and New Brunswick were mentioned by name. So in some statements, there's differences, like they're not treated equally in the Constitution. So it does make for a little bit of rigmarole, like to try and figure out what it is that I'm looking for. It's not consistent with what you're doing, is what I'm saying. I can't follow.
And Tara, I'm not opposed. I mean, I can't do the research in every province because I just don't.
No, I get it. I'm not asking you to. I'm just saying that it's
I'm
different.
not opposed to creating a group dedicated to Nova Scotia that I can at least, toss in my 2 cents when I can, based on what debates you've got going on in the group. Say, well, you know what? If I were you, I would maybe think about looking at this, or I might say I would think about looking at that. Right. And I'm already doing this with some people from British Columbia. So they're doing their own research. They're having debates among themselves, and I jump in every now and then when I have a little bit of time, just add my 2 cents.
Okay, sounds good. I was looking, we have I'm also a board member for CANS, which is the Citizens Alliance of Nova Scotia, that's the foundation that's bringing the judicial review forward in the course right now. But we also, because of CANS, we also have a platform. It's called the Nova Scotia Community Network, and it's just like Facebook. and I'm trying to get a group together on there to just do exactly what you said, which is discuss how Nova Scotia fits into the Constitution and how it's applied here, all that. Yeah, I can send you information so you could be part of that group, and but are you suggesting also be like set up a group for Nova Scotia on your page?
No, well, I was gonna say you can, no, because I've just been doing it in Telegram. So if you want to bring me into your group, I don't, hey, if you already got a group, keep the group. Just pull me into it. That works.
Yep. Yeah, that's fine. And again, you're doing it on Telegram. Okay. I'm not always on Telegram.
I'm on Signal. I'm on Telegram. I'm on a few platforms. So, whatever, if you guys, I'm just saying you don't have to, but if you want to pull me in, I have no objection.
No, I do.
I have no objection to that. And then when I can, if I can, I'll throw in my 2 cents.
Oh, that sounds good. Thank you.
Okay. All right. And then next question, iPhone. You got to take yourself off mute.
Oh, hi, it's Angela.
Hi.
With all this, that red tape that you're saying, like sometimes whether you'd have to get Freedom of Information Act to see, because they have all these names, are they just paying each other? Like, who knows what they're doing with those accounts?
Well, what are you looking for freedom of information for?
Well, no, because you were talking about that tax, red tax thing and stuff like that. Because to acknowledge that.
Here's the thing. I'm not looking to do a freedom of information. If I'm serving them a notice, I'm going to say, I'm sorry, what's the act of legislation? And I'm going to basically state the rule that they appear to be breaking, and give them a deadline of them to present what I'm looking for. And any acts or failure to act will be deemed to be an act of bad faith if they do not respond, to which they can be held personally liable for acting beyond their lawful capacity, beyond their authority of their official capacity, pursuant to Ron Corelli versus Duplessis. I'd be doing the application. I'd probably pursue this in small claims court, and whether or not, it's not about whether or not I win and make money. It would cost me a couple $100s to file the claim. They're going to have to spend all kinds of money on retainers and whatnot to counter it. And if they're successful in the countering, that's fine. And if they're, because I'm pursuing them for exceeding their authority, if I establish my argument correctly, well, then I'm going to win. And the point is that I don't have to necessarily sue every member of provincial parliament and every member of parliament of Canada. I just had to hit a handful of them in order to get the rest of them to understand that no, people come first, not party. Right? And I'm one person. Imagine the impact that would have if more people started to do that sort of thing. Not petitions, not letters, I disagree. I mean, literally taking some form of action to put them on genuine notice with respect to, it appears you're breaking this law. Show me this, show me that. What I've been doing, you can see on my website. I served every member of provincial parliament an email last week, which is on my website. You can see it. All 124 members of provincial parliament received this email that basically spells out what I just gave you guys, how the Reopening of Ontario Act is constitutionally repugnant. What it doesn't spell out is how it appears upon its face that the Attorney General violated Rule 5E, or maybe it does. I can't remember because I've been so busy doing stuff like this. So I've given them all a chance to respond. I've given them a deadline to fix this mess. And I've made it clear that any acts, or failure to act to fix this will be deemed to be an act of bad faith, and will establish them acting beyond their lawful authority when acting in their legal capacity, and they may be held personally accountable, which means I'm not going to go after the member of provincial parliament of Barrie Innisfil. I'm going to go after Andrea. Now, if a lot of people started going after Andrea, do you think Andrea might actually submit a bill to correct the error? Or do you think she's going to continue to sit on her laurels thinking, I can't be touched, I'm a politician? What do you think's going to happen?
Well, personally, that's what she's probably doing, because I got pissed off at her one time that she chose to go to a meeting over putting her vote in.
Mm-hmm.
You know what I mean?
Mm-hmm.
She doesn't really
Absolutely.
she doesn't have much to say. She's just, I don't know whether she's a puppet or not.
Well, here's the thing. I think I don't think these people are being deliberately against us. I think it's just, you got to remember, nobody in Canada knows a constitution exists. Nobody understands how all these laws get created. Nobody understands how the power is conferred by provisions of a constitution. And they've been slowly breaking the system and showing us with things like commissions, which mean nothing, that these people can't be touched, that we've all become, complacent in believing that these people can't be touched. And again, if we don't know how the system works, how do you expect these people that we're voting to represent us with the same lousy education we have, how do we expect them to know any better? The ones who probably should know better or are presumed to know better are those who actually had a legal education, because they studied the law. So those are the ones I'm truly holding accountable, because it is presumed they know. Now I'm going to go back here for a second, because there is a question in the group that says, do they have to swear an oath? And I'm going to presume that the question is in relation to the Legislative Assembly of Ontario. And right here, every member of Legislative Council or Legislative Assembly of any province shall, before taking his seat therein, take and subscribe before the Lieutenant Governor of the province, some person authorized by him, the oath of allegiance contained in the 5th schedule of this act. Now, whoever wants to go take a look at the swearing in process of June 2022 last year, they took a standard public oath allegiance. They did not do the allegiance set out under the provisions of the Constitution, which is the allegiance under the 5th schedule right there. Now, obviously, this one is written for the Senate, but you substitute and you put, instead of member of the Senate, you put member of the provincial parliament of Ontario, right? Because it says, or as the case may be. So that gets substituted for the office you're taking. And so all those public servants in the House of Legislative Assembly of Ontario have sworn the wrong oath. And further, this allegiance, to bear true allegiance to His Majesty the Queen Victoria, I am going to put out there that when based on the coronation oath of the Crown on June 2, the 2nd of June 1953, or somewhere in and around there, the Queen made 3 promises, which included protecting and preserving the customs law of Canada, and of course show mercy in the application of the law, and of course protecting the gospel. Now, gospel set aside because not everyone is Christian. Let's focus on the customs and the law of Canada. So, and the Crown also does not have any authority to tell us what to do under the provisions of the Constitution. So if the authority to tell us what to do is not provided for in the Constitution, and the Crown is sworn to preserve and protect our customs and our laws, then wouldn't it stand to reason that what this really means, this allegiance to the Crown, is in fact, dare I say, an oath to protect and preserve the Constitution? I'm just putting it out there for debate. So yes, they have to swear an oath. Every public servant has to swear an oath of one form or another, including judges. And no, our current Legislative Assembly of Ontario and Red of Ontario, Canada, has not sworn the correct oath. That's another point of contention I have with the Ontario Legislative Assembly. iPhone, did you have any more questions, or is that it?
Oh, sorry, that's, my hand was still up. Sorry about that.
No
Thank you.
problem. I gotcha. All right. So in absence of any other questions, I'm going to wrap up this session. I'm just going to stop the recording right here, but I'll say thank you to everyone for joining me this evening, and I hope I've shed a little bit of light on how I'm conducting my research and how I'm reasoning things through. I will state one more time, anything that I've shared here tonight is not to be construed or applied as legal advice. I'm opening these up for debate. I am not infallible. I need these debates in order to sharpen my arguments, because without them, I can't sharpen the arguments. I can't know if the argument is sound and irrefutable unless it's challenged. And I'm not afraid to alter my position when the proper argument is placed before me and presented. All right, so thank you so much, and I'm just going to stop the recording here.